Is to go. Start. In the present case, the learned single judge has held that in view of the circular which has been issued in the Director of Education on 4th August 2003, any amendment in the scheme of administration of the institution for extending the term by 2 years would be applicable to the term of office of the newly elected Committee of Management after the election is held on a date subsequent to the date on which the proposal for extending the term of office is accepted by the Joint Director of Education. The Director of Education had in fact in the present case clarified by a communication dated 3rd December 2012 that the enhancement of the term of the Committee of Management from 3 years to 5 years will not ensure to the benefit of the existing Committee of Management which has been elected before the resolution for the enhancement of the term has been passed and would apply to the Committee of Management which would be constituted after the elections were held afresh. On behalf of the appellants, it has been submitted that the learned single judge, while taking note of the judgment of the full bench and of the earlier decision of the division bench in Committee of Management, Arya Inter College (Supra) has lost sight of the fact that in the case before the division bench the approval which was granted by the Joint Director of Education contained a specific provision to the effect that the benefit of the extended term will entail to the Committee of Management of which elections were held subsequent to the date of approval. In the present case, it was submitted that the Joint Director of Education, while approving the amendment, did not impose any such stipulation and hence the enhancement of the term must also ensure to the benefit of the existing Committee of Management. It is not possible to accept the submission for more than one reason. Firstly, as the judgment of the full bench now holds, if the approving authority has the power in law to lay down a stipulation that an amendment shall be effective from a future date, then the amendment would apply in accordance with the condition or stipulation laid down by the approving authority. In the absence of any such special feature or stipulation, the amendment shall apply to the Committee of Management existing on the date on which the amendment comes into force. Applying this observation in the context of the UP Intermediate Education Act 1921, it is clear that subsection 5 of section 16A of the Act requires the prior approval of the Director to every amendment or change in the scheme of administration. Since the Director is vested with a statutory power to grant or refuse his prior approval incidental to the exercise of power, it is open to the Director to stipulate that the approval shall not ensure to the body which has proposed by a resolution the enhancement of the term full stop.